Welcome to this presentation held at PASC conference in Toronto. The presentation is about Denmark's new legislation on parental alienation. Called it Strengthening the Child's Rights to Both Parents. My name is Jesper Lohse. What I'll go through is the policy evolution in Denmark from 2007 to until today. I'll talk about the new parental alienation law that was started 1st of January 2025. We'll talk about the implementation issues, law effect, guidelines, safeguards and challenges, and also talk about the nationwide 5-factor testing going on right now, and the nationwide Take It support program for parents that has experienced parental alienation. In the end, I will go into how we use AI and AI agents on parental alienation, where we can go through very old cases and find parental alienation patterns. About the policy evolution in Denmark, let's start with 2007. Parental shared parenting is the norm in society. Shared legal custody was default in the law. Spousal support declined and reasonable child support was seen. In 2012, shared parenting was the basic assumption still by law, and it was emphasized that children has a right to both parents. Children's transportation was an equal responsibility of the parents, both if both parents were living in Denmark, but also if one parent were living outside Denmark. In 2015, we saw the first harassment package with automatic revisitation, holiday restrictions, and meeting obligation in family court cases. If the visitation was not upheld, it would automatically continue the next week without having needing to go to the family courts. Holiday restrictions made it sure that a child only could have holidays in the school holidays unless both parents agreed. And in 2019, we saw a major reform where we fired all the employees in the family state administration, and we created a new family court that was screening all children cases into a green, yellow, and red cases. This was very important symbolically for the parents that has to decide whether they wanted to be a green, yellow, or red case in the system. We saw double residence was made possible in agreement with parents. We saw family mediation and collaboration courses for free, and we created a children unit that were looking after the children doing family court cases. Every child has today appointed an adult that will look after them and be their contact person in the family court system. We saw psychological violence being part as the criminal law, and that also included parental alienation. In 2022, we then saw public information for both parents by law. We saw children allowance, which was the largest amount provided by the government, divided 50-50 by law. That also applies if you are living together as a parent. The father today gets 50% of the child allowance, the mother 50%. In 2023, we saw parental leave, that is 12 months in Denmark, being divided 50-50, with 3 months earmarked to each parent, and 3 months the parent can decide to have themselves or to give to the other parent. We saw family violence and crisis center being gender equal. Today, it's the support for women will also apply for men. So in 2024, equal parenting 50-50 was the fastest growing and mostly used by the parents in society. More than 60% of all children in Denmark has today 50-50% arrangements, and another big group is still children that is lacking contact with one parent. So therefore, we have introduced in 2025 a new reform on parental alienation with legal guidelines, and we have started up nationwide Take It support groups for alienated parents. So the family court system looks like this today in Denmark. We have the families where every case starts in the family courthouse. We have green, yellow, and red screening. So if green, the parents agrees, and they can fill out online forms, and they are basically handled automatically. If there's a yellow case, they will be invited for meetings to discuss what kind of disagreements do they have parents. There can be visitation, whether it should be 50-50 or another type of model, or different other parts about holidays and so on. The parents are offered free conflict and collaboration courses. The child is offered a free parent and adult, not parent, an adult from the children unit. And if it's a red case, the case will be handled, initially investigated and analyzed in the family courthouse, but then given later to the family court, where a judge and a children expert will look into the case, talk to the parents, and make a decision. That will see if it's a residential or custody decision that needs to be made, or if there's risk such as violent abuse, parental alienation in severe cases, then the case will be handed over to the family court. So, looking at the Danish family law today, Denmark is probably one of the countries that is furthest ahead, if not the leader, on the Council of Europe roadmap that was made in Resolution 279. This was a resolution that anonymously was decided by the Council of Europe toward equality in society. It has 10 aspects that is very important to ensure and implement in the national law. Items such as ensure that the parents have equal rights and receive the same information, remove any differences based on marital status between parents, and introduce into the national law the principles of shared residence. Denmark is currently at a 80% level on most of these parameters. We also have the introduction of paid parental leave that has been made all around Europe, where each parent has at least 2 months of paid parental leave in every European country today. Most of these, we are at a 80% level, which is probably higher than any other country in Europe today. On the respect for the child to be heard, we are stating that we're probably at 140%. I do believe we've gone too far on that the children are being interviewed too much by too many people in these cases. So maybe we should go a little bit down on that, still making sure that we hear the child, that we listen to the child. But let us not forget, this is the responsibility of adults. It is a responsibility of parents to secure that the best interest of the child is always secured. What we can monitor today in Europe is that the countries that are furthest ahead, that has the most equal family law, is also the countries that has less family conflict and have the most savings on the social parameters. But what we introduced in January 1st, 2025, to make sure that we look into and take care of all children and parents, was that we introduced parental alienation into the Parental Responsibility Act in Item 4. It was stated in the law that the family court and the family courthouse must, in assessing the best interest of the child, consider the child's right to both parents, and in that context, co-parenting obstruction, including parental alienation, as reflected in the child's behavior. Such obstruction shall carry legal consequences if it serves in the best interest of the child. We have introduced urgent contact within 4 weeks by law. We have introduced full examination of parental alienation cases or family court cases within 4 months, and we have put every member employee in the family court system on education, especially in parental alienation. The legal definition we work with originated from John Kelly and Jen Johnson, stating that parental alienation is defined as when a child persistently over a long period expresses strong negative feelings, hatred, rage, fear towards one parent, which are not in line with the child's experience with that parent. We have in Denmark created now a professional guideline that look into the child factors, age maturity, anxiety of the child. We are looking into the two caregivers, what is the positive behaviors and what is the concerning behaviors, what kind of parenting style are involved, what kind of looking after the children, how good are the caregivers to all these factors. And then we also look at the environmental factors, how long have the parents been involved, have created a relationship for the for the child. Is there parental leave? Has that been used? What type of conflict is there? Is there psychological sickness, abuse, violence, parental alienation in these cases, and so on and so on. So the professional guideline will go in and use a neutral and systematic approach to understanding contact refusal. There will be use of non-polarizing terms such as contact breakdown and contact resistance instead of attributing blame prematurely. So we have a commitment to investigate multiple contributing factors related to parental alienation and also including child vulnerability, caregiver dynamics, and broader family stresses. If we then look at the implementation, of course, there's a number of issues that is very important to have in focus. As I stated, the training is part of that, and all employees will be trained in parental alienation. We have the diagnostic complexity that identifying alienation requires multi-layered assessment that can be both time and resource intensive. We could expect some court delays because the 2025 law mandates quicker handling of urgent visitation, so staffing shortage may hinder such compliance. One of the major issues is, of course, the cultural resistance. Some actors in the family law system might still don't want to use parental alienation, but they have to by law, and they should. It's an important aspect. And on the other hand, there's a shift towards a more neutral and behavior-focused understanding of alienation. One of the important things that I feel we need to focus on very much is the major importance that parents benefit from good behavior and never being rewarded for harassment. That can be large or small, but we cannot reward parents for parental alienation. Then we will never be able to create a success and in the best interest of the children. Also, we need to make sure that mistakes are found, they are admitted, and we learn from them in the family court system. We need to create a learning system so that we can create a success and do it best possible for the largest amount of children and parents. Of course, safeguards is also very important against misuse, so we need to avoid premature conclusions. We need to investigate all sides with equal care, ensure the child's voice is heard and consisted authentically and also not heard too much, respect the child's right to protection from harmful contact. In my work, we look very much at risk management from a leadership perspective, that if we do not are able to make correct decision, or we don't make correct decision, then we will go down in the wrong direction, and we will see these cases where we suddenly have parents or children with post-traumatic stress disorder due to the family case. It's very important that we have first of all, a family law that is treating everyone equal, because if we don't have that, we cannot make the correct decisions. We will already from the beginning go down in the wrong path. If we find a mistake somewhere during the case, it's very important that we trace that information back, or that mistake back, to where it initially started. That can be in the law, it can be in a social worker, it could be at a court. But we need to trace back where did that mistake happen, so that we can prevent it from happening for hundreds and thousands of other children and parents. It is about risk management, and it is quite important to understand this from a leadership perspective in the family court system. We today know that we have some children hospitals where more children die than others, and we're able to find out what is the reason for that. We have mining accidents around the world. In Chile, we are able to get people up from mines while they don't are doing the same thing in China. Or it could be a space shuttle going to the moon where suddenly there is an explosion, and we need to be able to find out what was the communication that went wrong, what was the human mistake, the technical error that went wrong at that stage. And we are able to do process analysis in children cases to find out where does the mistake happens and trace that back and secure that that does not happen again. But again, if the family law is not in line with the Council of Europe resolution, we are not able to do the right things take the right decisions from the beginning, and we will already at that stage have gone down the wrong path, and that is why it's so critical importance that we have the right law and we have systems that is created as learning systems. This is basic risk management in what we could call complex human processes, but it's something that is well known in theory, it's well known in management, that you are able to create a success or a high level of success in even the most difficult human systems. So what is the law about, and what is the impact of the law? We have urgent contact within 4 weeks. We have full investigations within 4 months. We see transfer of custody and living residence, the Supreme Court verdict on that. We have national family mediation and collaboration for free. We have a new children unit also looking after the children in these cases. And we have parental alienation stated as psychological violence in criminal law. We have also started to see damage claims where if there's casework or local governments that does not handle parental alienation, then they are in a situation where damage claims can be made against them so that the child and the parents are getting financial amounts as a consequence. What we need to see in Denmark also still is we need to see the courts using the parental alienation law and providing sanctions so that we give everything from a few hours to 1 day more visitation for the alienated parent, and also using more 50-50 arrangement to create positive collaboration instead of not. And we need to see court cases where we still transfer custody and living address to the alienated parents from the alienating parent. What we would like to see, or I would like to see, is also court orders and maybe even therapy, but using the US and Canada examples of 90-day restrictions, where we don't have these black and white cases, but we simply go in and say that if you in a 90-day period, we provide peace and quiet for the child with no relation to one of the parents, to the alienating parents, to build up trust with the alienated parents and give the child peace and calm to be interviewed about what's really going on and send a clear signal, then we must see these type of decisions in severe cases to send a clear signal so that if you if you comply by the court order, then after 90 days, you know you will still have a relation to the child, and it will not just be lost. So the Danish law compared to international relevance, I would say it's child-centered, focusing, emphasizing behavior over parental blame. It's definitely integration of international research into national policies. It's a balanced approach to consequences, allowing court discretion to establish what is in the best interest of the child within a framework of child protection. It's a commitment to prevention and a commitment to early intervention with urgent contact through professional guidelines and systematic assessments. And it reflects, most importantly, a growing international consensus that the best interest of the child often depends on the child's ability to maintain strong and secure relationships to both parents. That is how we increase the love and care for the child, we improve the identity of the child, and we know that 50-50 arrangements, for as an example, provide a more peaceful family, more harmony, more quiet times for the child, and simply more love and more both social and financial resources. So I cannot emphasize enough that the Council of Europe resolution works. It's being implemented in Denmark, and also shared parenting and 50-50 arrangements to the largest extent possible is the best possible solution for most of the children, but not all, of course, in society today. There is a clear benefit of using these types of arrangements, also as default. So beyond the law, what we have done also is that we have introduced nationwide testing using the 5-factor model. It's possible to go in and take a free test to identify if there has been parental alienation. This is just an early warning. This is an identification that you can then go into the family court system with, where there will be a more deep analysis of parental alienation, and also looking into the positives related to the child. We have introduced nationwide take-it support programs where 6 to 8 parents are in a group, and they meet for 8 weeks, 3 times a week, either online or face-to-face, to discuss their experiences, their opportunities, to discuss how has the parental alienation affected them, and try to get improve the quality of life and some common grounds for having a better life, no matter whether you see the child or you will be in one of these new situations where you suddenly have residence for a child that has been alienated. So all these groups are handled, facilitated by professional therapists. We are trying to work with the parents, talk these things out, to make sure as many parents as possible are able to be the greatest parents they can be. Using the 5-factor model, we have introduced the national test, and we have more than 1,000 have been using it already. So we are able to monitor, for instance, on the 17 behavioral factor from alienating parents, what is the top 5, what is the happening in the individual cases stated by the parents that we need to be aware of. Not the same as stating that it has happened, but this is the impression experienced by the parent. We can see that in 82% of the cases, undermining you as a parent is the key, interfering with communication, limiting contact, making false allegations, or withholding love if you are together with other parents. That is the top 5 in our national analysis. Related to the child behavior, we also have these 5 different levels we looked at, and we can see that lack of understanding for the child, the different sides, is one of the key consequences. Reflexive support of the alienating parent, but also fear and anxiety about visiting the parent is one of the top issues for the children. What we then also ask the parents during these national surveys is, how has parental alienation affected you? And the top answers there is that 79 state that it has catastrophically, significantly affected the relationship to family. It has affected the child's well-being, but also the trust in authorities. That Denmark is normally a country where you have a very high level of trust in authorities, but parents that experience these cases because it's not been handled, because there's been discrimination in family law, because parental alienation laws contact false accusations have not been handled. There's definitely an issue with trust in authority, and of course that's very important to focus on. That's something that we should preferably not have in a society. What we're also able to do is to establish that about 28% of the alienated parents has had or have suicidal thoughts, and this means that we are actually able to hopefully save life, to make sure that we try to help these persons as good as possible, to assist them with helplines and things like that, to talk things through. So that was about the new legislation in Denmark. Besides that, we are today able to analyze parental alienation in totally new ways. We are using AI and AI agents to go through cases that can be 6 or 10 years old, with thousands of documented pages in cases, and we are able to find and establish identified parental alienation cases. So we can use AI today to identify, we can use it for formal complaints, for legal cases, we can create child and parent relationship reunification plans, we can do damage claims, and some of the latest things we've seen is emotional support, where if you are an alienated parent, you can go in and say, how do we improve quality of life for you in a very difficult situation? So that can be about communication, it can be about gathering together with other persons, but it can also be diets and exercise and things like that, that AI can create plans for. So what we have done also in Denmark at this stage is, because we are at 80% on the Council of Europe roadmap, we have found it necessary to reach 100% to start what is the largest human rights case for shared parenting and children going on right now at the Human Rights Court in Strasbourg. We have entered the case in Strasbourg, but we also are running a case that was started 3 years ago in the Danish civil courts. So we have shortlisted, or we have listed, made a list of 360 items in family law that are discriminating, where parents are not equal, and therefore we cannot make the right decisions in family court cases. That list has been shortlisted down to 25 legal claims together with lawyers. So right now there is a civil case going on. It will start January 19th, 2026 in Denmark at the national courts. But right now it's also transferred to Strasbourg, to the Human Rights Court there, asking them to start it up besides the national Danish system, because it's a principal case for many other countries around the world. So in the 25 legal cases we have is items like double residence and equal parenting shall be the basic assumption by law. We definitely want to remove the residential and non-residential parents. There's a very large difference in legal rights, in welfare benefits, in the opportunities being together with the children, whether you're a residential or non-residential parent. At the same time, in the Nordic countries, welfare benefits is based on it's not based on actual needs, but should be. They're based on residential parents, so therefore we have many conflicts around that. And parental leave should apply in all family forms. Also, if you are not living together, there is some possibilities to get typically the father out of the child's life, and we need to secure that of course not will happen. So you could say we are living in a shared parenting world with single parenting law. That is definitely what we have analyzed happening in most countries around the world. And we are able to monitor the countries that has the most equal family law is also the countries that has the less cases and they have a higher level of satisfaction by parents, by professionals, by children in the family court system. Later in life, they will be able to monitor also the social impact that they have less amount of children with social-psychosomatic illnesses, less use of medicine, less amount of social cost in society. So I have no reason to doubt that we will succeed on this. This is a development in society, but we need to balance the work-life balance because we have more women than ever before, and that's extremely positive, going into the educational system, being well educated, also being top managers in work life. Then we need to make sure the balance is the same in the family life, that we provide the role models for the fathers with equal opportunities there, because that is the balance that we need to see in the families ahead if the children shall not be the losers in the end. If the child has two parents only thinking about work, then definitely the child will lose on this. So the work-life balance is extremely important. It's extremely important when we have gender equality in work life, that we also have it in family life. That is in the best interest of the children. So in the end, I'll just make sure there's some more information. We have made a Nordic Father report together with our partners, which is both Foreningen Far in Denmark, VBU in Sweden, Mandsforum in Norway, and Lastenurken in Finland. We have asked 4,500 fathers what is the status on gender equality in family life, what is the key challenges, what is positive, and so on. So you can buy it very cheap on Amazon. It's available there. And it's a report that is made towards the UN Global Goals, where we address goal number 3, good health and well-being, and also global goals number 5, related to gender equality. The global goals for sustainable development, of course, need to address the boys and men issues, also need to address gender equality, human rights, and the best interest of children, not only women's. More information can also be found at Amazon in the Father's Guideline. This is the catalog I developed first in 2017, and later has been updated. In the first version, there was 348 items that was discriminating parents on family forms, on non-residential, residential parent, and directly and indirectly on gender, whether you were a father or mother. The catalog divides the different items into 12 different themes, and it's possible to go through and see how have we shortlisted the human rights case, but also how are we pushing reforms, and for what reasons are we pushing reforms in Denmark right now. We have definitely in Denmark used a media strategy compared to other Nordic countries, that we have simply been able to gather this information, brainstorm information, but also put them out every week in press releases to all parliament members, to all national media, that this is items we need to look at in the best interest of the child, and to make sure that everyone is equal before the law. You can go in on our website, worldparents.org. You can go in one of the partner websites, the Nordic organizations. You can go into my Facebook. You're welcome there, the official Facebook page, or LinkedIn. And as mentioned, you can either, if you have Kindle, it's free to download the catalog, but it'll also be a price about $5-10 to buy it on Amazon or Reports and Work. So with that, thank you very much for this opportunity to present at PASC in Toronto. This was the presentation about the Danish family.